Is a managing partner of a team of distinguished attorneys in Pasadena. Paul has extensive legal experience in small to large business operations and commercial real estate transactions. He has counseled individuals and businesses at all levels in a variety of transactional and litigation matters, including contract, landlord-tenant, land use, employment, franchise law, fraud, identity theft, business immigration, civil rights violations, products liability, trademark violation, and construction deficit and general torts. Excuse me, construction defect and general torts. Prior to entering private practice, he was deputy city attorney, city prosecutor, mediator with the city of Hesperia. He wants to bring his many years of professional, community, and education experience to help the council solve these problems. Paul is a member of the Arcadia City Council. We are thankful to have Paul with us this morning. Please join us and please join me in welcoming Paul. Thanks again, Paul, for being here.
Yeah, well, thank you, Jim. I just really want to welcome all of you. I'm so excited because I really enjoy small groups. Typically when I lecture, it's really big. And I love intimate settings because it's going to allow us to dive into information, and it's going to allow us to have the ability to have people ask questions that are going to be more specific. And I'm going to really be able to kind of flow through a lot of the questions and listen to them. As I was preparing for today, I was kind of wondering what were the issues that people were really interested about. And obviously, the laws in a COVID world are the most interesting. And so that's really what I'm going to focus today about. Very quickly, I wanted to say that the presentation today is for general education purposes only. And if you need to find an attorney, you really should go find one. The PowerPoint is going to be available for everybody, but I do want to make sure that you are understanding that there's no attorney-client privilege, as well as the association. They're not making any claims that this is the right area of law. However, it's really going to deal with real estate. I am part of the city council, but I do want you to know that when I lecture, I kind of divest myself of that thought because I really want to be able to present it to you from an attorney's standpoint. And so please understand that I'm not making any representations from the city of Arcadia. I am going to have slides from the city of Arcadia for purposes of helping you understand our goals for today. Our lecture plan for today are several. The first one is to go over the current laws during a COVID era as it relates to real estate. And in my opinion, the best part of the lecture that you really need to understand is one of eviction. I think that's very important because, excuse me, it's kind of funny. Any burp, any cough, anything, even if it's by Zoom, people still hesitate. I do too. So it's the funniest thing, but I do have a burping problem all the time, so I'm always coughing and burping, so I apologize for that. The current laws during the COVID era, I think, are critical. The LA Superior Court in particular is opened up for eviction. So I don't want you to feel that the COVID laws that are in place are going to protect people from evictions. I know this is very different than what you're hearing out there. Yes, there are a lot of rules that protect tenants when they don't pay rent, but I want you to know that the eviction courts are open. They are not closed. In fact, I was just there yesterday defending a commercial tenant. So I want you to know that. The next one is the future 2021 laws related to real estate. The big one I found was ADU, and I'm going to explain to you how the ADU and JDU works so that you can be able to achieve more profit and more business for yourself in 2021. And also I'm going to talk about just some real estate projections that I have and considerations that you must think about in the year 2021. So just very quickly, before you understand any COVID laws, a lot of us are Google searching, which I do understand, but I want you to know that you have to understand the laws that are currently in place before you make a decision. So the example that I give that is very easy to understand is employment law. And that is that you cannot legally discriminate, wrongfully terminate, or fail to properly pay your employees. Why is that important? because a lot of people, what they've done is they've jumped straight into learning about the new laws of COVID. They have forgotten that there are a lot of laws, tens of thousands of laws that are currently in place throughout the state of California. So an example that I give is Labor Code 558.1. And what does it say? I know a lot of us are looking by the phone, so I'm going to explain the PowerPoint. It basically says that any employer or other person acting on behalf of the employer who violates a employment law as it relates to wage and hour is going to be personally liable. So let me give you an example. Let's say at your real estate company, you are also the office manager. And as an office manager, you are in charge of paying wages to the employees of the company, This statute under Labor Code 558.1 essentially says that you could be personally liable for the wages of the employee as an office manager, even though COVID is in place, because Labor Code 558.1 was already in place before COVID. COVID doesn't stop the laws that are in place. So if the statute further says a person that is acting on behalf of the employer is a director, officer, or managing agent. Director, officer, or managing agent. So as an office manager, are you a managing agent? The answer is yes. So I don't want you to think that every time we learn about COVID law, as it relates to real estate, employment, business, et cetera, that somehow you can be able to relieve yourself of the prior law. You need to understand the prior law before you understand the current law. And that's what we're going to do today is we're going to bounce back and forth between the current law and the COVID law as it relates to unlawful detainers so that you can be able to understand how you can be able to use COVID either offensively or defensively. But please don't, in your mind, divest yourself of the prior laws that are in place, okay? These are the 4 laws that you really need to understand as it relates to eviction. There is a governor moratorium. So the governor has put something in place. There is something called AB 3088 for residential evictions based upon non-payment of rent. There is also a county moratorium, such as Los Angeles. They have the strictest county moratorium. And attorneys aren't going to go into this because we don't necessarily know the outcome of it. But the county of Los Angeles, for example, has departments within the county. And they've basically said, departments, you need to issue guidelines so that people can be able to understand what the county moratorium is. Well, I'll give you an example. There is a guideline in one of the departments in Los Angeles stating that if a lease ends during the COVID period, which is now until next year, as of right now, it's until February 1st, if a lease ends, the lease is automatically extended until 2021 February. And that was the issue that we were arguing about yesterday in court. There was a landlord that was trying to evict my client, a commercial tenant, that pays about $80,000 of rent on a monthly basis. So it's a fairly large commercial tenant. One of the arguments that we were making is that the department within Los Angeles County has issued for both commercial and residential that when a lease ends during the COVID period, which is during this time, it's automatically extended. There's no answer for that. So plaintiff was arguing that the department was merely a guideline, but not necessarily a law. We are arguing the county moratorium is law and allows for departments to make determinations on what law is, and therefore it is the law. So today, when you're learning AB 3088, as well as other areas of law in relation to evictions, understand that you have to dive even deeper if you really want to evict a tenant, whether residential or commercial. But you are going to learn the basics today. How are we doing on volume? Are we doing okay on volume? Volume okay? Okay, well, hopefully volume's okay. If not, please send a message so that everybody can be able to know that you can't hear me. So here is a quick summary of unlawful detainer. And the reason why I want you to see this is because I've not found any flowchart online that is able to help you. So this is before COVID. So this allows you a basic understanding of how unlawful detainers work without COVID. So on the left side, you basically start here, and the tenant doesn't pay rent. The property owner or the manager serves a 3-day pay or quit or other notice, sometimes 30 or 60 days, to get them out. The right square basically says the tenant moves out or pays within the number of days that are given. If the tenant doesn't move out, what do? Well, you've given notice, and then you need to file and serve a summons and complaint. All right. Now, this slide that I have is, again, before COVID. So please don't confuse it. It's very important that you remember that. So basically, a tenant doesn't pay and you file summons and complaint. Next slide. The tenant is then served with the summons and complaint. The right side basically says the tenant moves out or pays all the rental fees. Now, let's say that the tenant refuses to do so. The left chart basically says if no answer is filed within 5 days, you basically get a default. And then there's a default hearing, and then you basically get a judgment, and then the tenant moves out. The right side basically says that the tenant then files an answer. When a tenant then files an answer, you're going to do what's called discovery. Discovery in the United States is very different than in the rest of the world. It allows you to get information from the other side, for example, depositions, written discovery. But the reason why the rest of the world is different, and when I say different, I don't mean Asia. Asia follows European laws. So basically, the United States kind of broke away, created its own system of litigation, and the rest of the world continued to follow Europe. So Europe has very little discovery laws, meaning basically you don't have that ability from one side saying to the other, give me all of your information. Another example is a deposition. Everybody knows about depositions. You can find it online. Everybody gets deposed. Bill Gates has been deposed. You can find it online. Justin Bieber has been deposed. And I think just yesterday, Ivanka Trump was just deposed. Well, in the rest of the world, depositions are for criminal actions, not civil actions. In the United States, depositions are for civil actions, and criminal depositions are only if the defendant is willing to do so. Why is that important? In an unlawful detainer, you're allowed to ask information back and forth. Typically, in a regular civil case, you have 30 days to respond, meaning if somebody asks you, give me all of your reasons why you want to evict the tenant, you have 30 days. But in an unlawful detainer, it's 5 days. It is only 5 days. And it's a very aggressive way of litigating because everything needs to be responded to in 5 days in discovery. You can have a deposition of a person within 5 days. You have to answer discovery questions within 5 days. And I think the reason why we've been very successful in unlawful detainers is we're one of the few firms, and I'm not saying that we're better, we're one of the few firms that issue discovery during unlawful detainers, both on plaintiff and defense. Why is that important? Well, if you don't answer discovery, you go to the court, and the court basically can say no defendant or no plaintiff, you must answer discovery, and you must pay money, attorney fees, to the prevailing party. So it's very important for you to consider when you are evicting a tenant to consider doing discovery. Is it more expensive? Yes, but your probability of winning, whether you're on plaintiff or defendant, is very, very, very high because evictions in California has become a flat fee basis, meaning that most attorneys do it on $750 or $1,000, $1,500. And what ends up happening is if one side is more aggressive, the attorney that is either defending a tenant or prosecuting on behalf of the landlord typically won't work. And you're able to prevail. So the next one is, once the defendant files an answer, then you have to do what's called a request for setting, The court date is going to be set essentially around 20 days out, and then you basically litigate. Now, I do want you to know this. Although yesterday I was in LA County, defending a lawsuit, and it wasn't for trial. I did see jurors that were there. Now, the jurors that were there for criminal actions. The Los Angeles Superior Court, when we've talked to all of our judges for our civil actions, have said they are not doing jury trials. Now, why is that important for you to know? Because if you are prosecuting an eviction, you're going after the tenant. All the tenant has to do is ask for a jury trial. And if the tenant asks for a jury trial in a timely basis, you're not getting the tenant out, even if you have very good grounds. Let's just say that the tenant is, just in Arcadia yesterday, there was a pot bust. There was, in the northern side of Arcadia, there were 1,000, it was just a pot bust, right? And so the police were there and they're doing their investigation. And now you want to evict the tenant. Very reasonable to do so. Is it based upon a not wanting to evict the tenant based upon a non-payment of rent? Of course not. It's a nuisance. However, if the tenant then asks for a jury trial, you're looking middle of next year, late of next year, and that's going to put you in a very difficult position. So you always want to try to resolve with the tenant if you can, particularly during the COVID period. So that's lesson number one. Jury trials, very hard to get in Los Angeles County. Please try to resolve it with your tenant if possible. Then what you do is you go to trial. Now, we're bouncing back when there's non-COVID. You basically hopefully obtain a judgment, then the tenant moves out on their own. If they don't move out on their own, you get from the court what's called a writ of execution, and then the sheriff goes out and basically locks them out. What the sheriff does typically that I've seen is the sheriff will go out and give a 5-day notice. You need to leave in 5 days. Then they're going to come out a second time and say, you need to leave within 5 hours. Then you can lock out. You've been told this a whole bunch of times, whether commercial or residential, that, you've been told many times you cannot use self-help. What does that mean? Self-help basically means you turn off the electricity. Self-help means that you change the locks. Self-help means, and I've actually seen this, we're defending a lawsuit in Koreatown. And basically the master landlord, so what the master landlord, when there's a master landlord, what that means is they own the whole building. And they basically almost sublease the entire building to us, and then we have a whole bunch of tenants. And when my client wasn't able to pay all of the massive rent that was due, the master landlord sent in a whole bunch of quote unquote security guards that look like police officers. That is called self-help, and that is illegal. The only two things that you can be able to do is you use the court system to evict, and then you need the sheriffs to physically remove people. You are not allowed to do it in any way, whether it is pre-COVID, during COVID, or post-COVID. And the third way, obviously, is to say, you know what, let's just settle the case, have a date, have a contract, you move out on that date. And even if the tenant breaches that contract, you are not allowed to self-help. So I've seen contracts that said, I'm gonna move out on December 30th. December 30th comes and the tenant is still there. The landlord turns off the lights, electricity, even commercial, turns off the electricity for commercial. That is illegal self-help. And if you are sued, you are going to lose. And then there's the final eviction. So we are done with the unlawful detainer, and let's go into COVID. So here's a link that many people don't know about, but I want you to know that I give this to every attorney that calls me. These two links are really duplicative. Sometimes they go down, but it summarizes all 50 states. I'm going to repeat. It gives you all 50 states COVID laws as it relates to evictions in real estate, you need to have this link because you need to read these if you want to know about COVID. And every attorney that practices unlawful detainer, they better have this link handy. And therefore, I give it to you. So one of the reasons why, and again, probably because it's a small group today, it's really exciting, is I'm able to really articulate kind of from a different view. When I lecture, I want to give you something that nobody else has given you. You can be able to use it. So in case you're taking a shower or you're just doing whatever you're doing on the side, you're going to come back to the PowerPoint. You're going to be like, oh, wow, you know, there's something in here. So this is not necessarily a secret link, but it's what every attorney uses to begin to understand COVID law in all 50 states. Now, I've only used it for California and Nevada. Both of them are delayed by about 2 weeks, 2 weeks. So I do want to say, okay, I apologize. There was a message in here, but in front of me is my phone. On the left side of me is my PowerPoint. So I can't always go back and forth, but I do want you to know it's going to be very helpful, very, very helpful for you. And in fact, I've used this link even in preparing for my PowerPoint today. So I've also provided other links for you. These are all very good as it relates to Los Angeles. So I've given you the government's executive order, Governor Newsom's executive order, his memo regarding eviction moratorium, executive order regarding commercial evictions. A lot of people don't realize there's something separate apart from that. I've given you Mayor Garcetti's order, all different links that will help you to be able to understand. Now, this here, I'm not sure if this was a missing link, but I'm going to double check. And if need be, I'll supplement that. But I do want you to have these links handy. So again, the prior link is this Westlaw link that summarizes all 50 states. These are the most relevant links, I think, related to Los Angeles County and really for the AAR today. So AB 3088, we're going to go over residential, then we're going to go over commercial. So no evictions, February 1st, 2021, for rent owed between March 4th and August 31st, if the tenant provides a declaration saying that they have a problem because of COVID-19. The rent still is owed, but it's converted to a civil debt. I'm going to explain what that means. Now, obviously, we're after August 31st. So what does that mean? Between September 1st and January 31st of 2021, you still cannot evict a tenant based upon a COVID-related financial reason. On January 31st or February 1st, depending on which attorney that you speak with, if they pay 25% of the rent that's owed, they can avoid eviction. So what does that mean in terms of rent owed? It can only be rent. If you are attaching fines, service fees, those are not part of rent. And in fact, the statute says that you cannot do that. So I've seen a lot of tenants, residential and commercial, that have come to me to say they don't know anything about COVID, but they are willing to pay rent that's owed so they can just stay. That's typically what people come to me about. They don't know the law. So they say, but before I owed 10,000, now it's 15, 20, 25,000 because of all the penalties. And the answer is that's illegal. But related to the 25%, again, it's just rent owed only. If they pay rent owed, then the rest of it becomes a civil debt. Now the question becomes, if they pay 25% of the rent that's owed, and then they stop paying February and on, can you be able to evict them? The answer as of today's date, the answer is yes, you can be able to evict them. Now, what is a civil debt? A civil debt basically means that if somebody pays 25% of the money that's owed between September 1st and January 31st, then what about the 75%? That's a really huge issue. Basically, you need to go into small claims court to be able to sue. Now, understand that there is some ambiguity in the law, and I'm a little bit concerned, and I'm going to explain that a little bit on the last point of this next slide. Earlier, we learned about a 3-day notice. A 3-day notice basically means you need to pay rent or you're going to be evicted. That changes to a 15-day notice. It's no longer a 3-day notice, but a 15-day notice. And the reason why that's important is because on every situation now, we are recommending a 15-day notice. Now, there are a couple more problems. The hardship declaration needs to be attached to the 15-day notice. I repeat, when you serve a notice, any type of notice now, there is something called a hardship declaration. If you negotiated with the tenant in a foreign language, and the foreign languages available, I believe, are Chinese, Tagalog, Korean, Spanish, one other language that I don't remember, but I don't have clients from that community. But the hardship declaration needs to be in that language. Is it translated for you? The answer is no. Unfortunately, the government has not translated that, at least I've not found them. So you need to hire somebody to translate these documents so that the tenant can be able to respond. Now, here is another problem. If you have currently a tenant, and you have not in your original lease agreement translated it into a language that you negotiated with, that lease agreement is also void as a matter of law. So the problem that I have is sometimes pre-COVID, we have a tenant that is Mandarin speaking, and the landlord is Mandarin speaking, but yet the landlord-tenant agreement is in English. And what ends up happening is the landlord says, I want to evict the tenant, I want to get them out, they have not paid rent under the lease agreement. And I said, well, what did you negotiate under? Is the tenant going to ask for a translator? And the landlord says, yeah. The problem is that we're not going to be able to get any rent. And there is a risk that the tenant can sue back because it's a void agreement and ask for all of their rent back. So I do want to say, very risky. It's now doubly risky because of AB 3088. Point 5. Now, does it relieve the tenant to pay rent? No, it doesn't really. It's not rent forgiven, it's rent delayed. All right, so if AB 3088 you think about as not rent forgiven, rent delayed. I'm going to get back to what it means for a civil debt collection action in small claims. Point 6 says, again, it allows landlords to recover the rent owed from the COVID period as of March 1st, 2021, through a civil debt action. You need to file a small claims court case. What I did not see is this. The prior law that was in place, was Civil Code 1161. It's still there. It only allows for residential tenants, you're only allowed to get back 1 year. This is something that I've not been able to find an answer to, because the small claim retains jurisdiction for collection until February 1st, 2025. However, because of Civil Code 1161, with only a 1-year statute of limitations to be able to collect rent for only 1 year, I believe that as soon as the small claims opens up, you must file for the 75% that's due and all the other money that's due prior to as well. Now, if you have a local moratorium, the city of Arcadia had a local moratorium and it is expired. But there are other moratoriums in other cities. I did not spend the time to put all the city local moratoriums on this PowerPoint. It is online. If you email me, I can be able to send it to you. However, AB 3088 says it permits existing local ordinance to remain in place until they expire. However, if a local jurisdiction such as City of Los Angeles, Arcadia, etc., they want to pass any more moratoriums, they are prohibited from passing any extensions related to residential evictions for non-payment of rent. So basically what that means is local moratoriums aren't going to be put in place. AB 3088 controls. Oh boy, Unfortunately, I'm taking a little bit too much time on the PowerPoint, but I'm going to do my best to try to get through all of them. So I apologize if I'm speaking a little bit slow. So what can you evict on as of right now? You can evict on things that are not related to rent. And so I'll give you an example earlier is that if you in your tenant is pot, right? And they got caught, illegal drug bust. That's a nuisance. You can be able to evict for that. However, can you be able to evict if the lease is up and there's no fault of the tenant? The answer is if the lease is up, unknown, if it's no fault of the tenant, likely not. So this is very scary, and I'm going to explain. This is the DCBA. What is the DCBA? The DCBA is the Department of Consumer and Business Affairs. They are an extension of Los Angeles County. And what it is that the DCBA shall issue guidelines to aid in the implementation of the moratorium, including but not limited to the guidance regarding the way in which tenants can certify they are entitled to protection under the moratorium. Why is this important? Most attorneys are not reading DCBA. Most agents in the real estate industry are not reading the DCBA either. They are basically reading all of the, if they're really working hard, they're reading the governor moratorium, the county moratorium, but they're not reading the DCBA. This is currently, there's no case currently on appeal whether the DCBA guidelines are law. In my opinion, it depends on whether you're being conservative about whether the DCBA is the law. However, from my standpoint, I take the position that the DCBA guidelines is the law. So another portion of the DCBA, and I've provided the link to you, it says, through the duration of this moratorium for any reason not based upon any alleged fault of the tenant, and tenant is residential and commercial, including but not limited to the reasons set forth, you cannot be able to evict the tenant unless the eviction is reasonably necessary to protect for the health and safety of the occupants or those who live and work nearby. So this is a very strict guideline. Hopefully I didn't scare anybody with the DCBA. This is the DCBA guidelines. It took me a long time to find it. I don't know why. So the DCBA guidelines, if you just say DCBA guidelines, County of Los Angeles, the link that it gives you is an older version of the DCBA. This is the newest version of the DCBA. It was amended as of November 10th or 16th. And that is the link that you need to read. And the funny thing is that when I go to court and the judge pulls up DCBA, the judge says, no, your version is wrong. I said, no, my version is right. This is the link. This is the link. The one that's online that if you Google search it, it is based upon, I believe, June or May. It's very old. And 5.6 of the new DCBA says, where a lease term ends while this moratorium remains in effect, what does that say? The lease term is extended until the moratorium ends. So, in my opinion, the plaintiff that is trying to evict my commercial tenant that basically says that they are a holdover tenant because the lease expired during the moratorium period, I believe is wrong because the DCBA guidelines say, based on the Los Angeles County moratorium under 5.6 of the DCBA guidelines, where a lease term ends while this moratorium remains in effect, which it is, the lease term shall be extended until the moratorium ends. And therefore, if you're trying to evict my tenant because he's not paying any rent, then you are not going to be able to get the property back until the moratorium ends. So this is very important. And again, if you aren't focused on anything today, one, you have the link for all of the 50 states. You now have the link for the DCBA that you cannot easily find online. And now you can be able to read 5.6. Depending on whether you stand on the landlord or tenant, it's pretty scary. This link provides you a summary on whether you qualify in California or even all 50 states for eviction stoppage based upon a non-payment of rent. So this is a great link that is able to help you be able to see if you qualify. And here's an acceptable form for a COVID-related loss. So if you click on that link, it gives you a standard format in which you can be able to articulate a COVID loss. Here is the commercial tenant. Commercial tenants are not protected under 3 reasons for any eviction. Not protected. If you have over 100 employees, if you are, and a lot of attorneys have forgotten this, a multinational corporation. So let's just say that you're a company over in China and you come over to the US and you have 6 employees here. Are you a multinational corporation? In my opinion, you are. So if you're on plaintiff's side, you can be able to evict them. The last one is a publicly traded company. I'm pretty sure everybody thinks that that's very reasonable. If you are a commercial tenant, you must provide a COVID financial impact form within 7 days of when rent is due, unless there's an emergency and you can be able to show that. For example, you were sick or you were providing care to somebody else. Now, commercial evictions in general are not given as much protections. So it's very important that every time rent is due, within 7 days, you provide a COVID financial impact. If I was evicting a commercial tenant, I would say they didn't provide it. They didn't provide it, and therefore I can be able to proceed. Let me see. Oh, this is self-certification. In the financial impact related to COVID-19 pursuant to 6.2a, if the tenant provides the landlord with a written signed self-certification establishing a financial impact in a form substantially similar to the self-certification guideline in attachment A. I didn't include it as a link, I didn't have time, but if you go to the DCBA guidelines, it provides that attachment A for you. A tenant's failure to provide a written signed self-certification in a form substantially similar to the self-certification does not preclude a tenant from establishing a financial impact, meaning it doesn't have to be identical to the self-certification that the government provides. You just need to be able to say, look, my business is substantially harmed due to COVID-related reasons. Now, in terms of commercial, there is something that's very important that a lot of tenants on a commercial side aren't doing, and that is 2AC. Commercial tenants with 10 or more, but fewer than 10 employees, shall provide a landlord with documentation sufficient to demonstrate a financial impact related to COVID-19. So what does that mean? If you have 9 employees or less, you can be able to just self-certify. You say, under penalty of perjury, I have all these problems related to COVID-19. That's done. However, if you have 10 to 100 employees, you need to provide more detailed information. And really, you need to be willing to give over your financial information. If I'm evicting a tenant and they've given me self-certification, that's actually not enough. So there are a lot of tenants that are squeaking by, a lot of landlords that don't know the law, and the COVID-related financial impact form is not compliant. The question is, are you willing to sue on a non-compliant COVID-19 financial impact form? Most landlords have been unwilling to, but there are landlords that are willing to make that risk and go forward. Commercial tenants with 9 or fewer employees have 12 months to pay back their rent. 12 months to pay back their rent. This is very important. However, if you have 10 or more employees but fewer than 100 employees, then you have 6 months to pay back your owed rent from the date the moratorium ends. Obviously, if you and the tenant and the landlord are willing to agree to an alternative payment schedule on a commercial side, that's allowed as well. So let's get to, we've dived into the AB 3088 for residential. We've dived into the commercial issues. Let's talk about ADUs. Let's talk about ADUs. So ADU was a very hot topic for 2020, but guess what? COVID happened. So a lot of people don't know about ADUs. And I'm just gonna barrel through this because we don't have that much time, but really research the issue of ADUs. I believe that ADUs are really going to allow a lot of property values to increase. And ADU link for the government is 2020. There's really two acronyms. One is ADU, and that is an independent unit from your property. An independent unit from your property, and it can be fairly large. The second one is called a JADU, and what a JADU is, it is increasing livable square footage of your property, typically a garage. So for example, in Arcadia, you have many homes that have three spaces for the garage, for cars, and typically you only have two cars that are in there. And therefore you have one space that you want to convert into, I forgot, man cave. I hear that all the time for JADU, man cave, right? The house has to be totally clean, but we're going to allow a place that everybody can be able to go in, the family can be able to go in to have a lot of fun. That's called a JADU. And so that's the link for the government. Arcadia has a link as well. Many of the cities, because of COVID, really didn't comply with the law to try to explain what ADU is. I think Arcadia has provided an excellent link for you to understand what ADUs are. I do want you to know that in 2020, there were not that many applications for ADU. Arcadia and other cities. But I really believe in 2021, to increase the value of property, you may want to consider asking your client to look into ADU, because obviously if you have more livable square footage, you are able to essentially be able to increase the value of your property. I'm sorry, one of the things that I always have to do is I always have my Arcadia email open. And the reason why is if there's something urgent that comes in, particularly during COVID, I'm looking at it. I have these emails kind of going up, so my eyes are darting back and forth, but I really do care about lecturing today. I just need to be responsible. I apologize for that. So AB 3182 basically says that if the city doesn't, if your city does not approve a ADU application within a specified period of time, really it's just several weeks, it's considered granted. And because a lot of cities, unfortunately, are not familiar with ADUs, they basically are letting them lapse. So now is actually a good time if you are considering an ADU to apply for ADU right away, because most of them are lapsing, and when they lapse, it means it's automatically granted. So that's one of the things that you need to consider about. I can tell you Arcadia is very excellent, though, about getting back to people, so they will respond to you. We have several slides left. I'm going to try to get through it as quickly as I can. We have not that much time left, and we need to go over Q&A. So future projections. So these are future projections that I have. Real estate market will remain hot because of the interest rate, but if there's an increase in the interest rate, people aren't going to buy. So you have to keep your eye on the interest rate. Some people have said that this is kind of a bubble that's occurred, and that is very risky. So if you are looking at real estate purchase and sales, if the interest rate suddenly begins to go up, even a little bit, people are going to stop purchasing. I do want you to know in Arcadia, very hot real estate market. Just across from me, homes, $3-4 million. I thought to myself, well, nobody's going to buy right now. Already in escrow, pretty amazing. There is a significant decrease of foreign money into the United States. Just yesterday, Congress passed a law that basically said that if you are part of a communist party, if you're affiliated with the Communist Party in China, you are not allowed to come into the United States, and you are not allowed to become a U.S. citizen. That's pretty significant because although everybody claims they're not part of the Communist Party, people are associated with it if they're from China. Particularly in Arcadia, you have a lot of China money, what's considered China money. The question I have is China going to retaliate? So, COVID-19 has all of these small issues, but I want you to kind of see these issues beforehand. I was on a phone call with an assemblyman in the state of California just last week. And one of the questions that I asked him is, hey, what about the vaccine? When is it going to come? Everybody's saying in the news that it's going to happen within the next couple months. And he was very forthright. He was very open to the group that was there. He said that none of the elected officials in Sacramento, from his standpoint, really believes that there's going to be a vaccine. that's going to be coming out and distributed, because we asked him, well, how's the distribution going to work? We're so excited about it. And he said that basically it's not until the end of 2021, his belief, until there is the availability of vaccines for the general public. I see it differently on CNN, Fox News, et cetera. But again, this is something that we have to consider. Another one is traveling in and out of the United States. Is it going to be a requirement that people need to have vaccines before they go into another country? Right now, there's only a handful of countries. In Europe, you can't get in. England, you have to quarantine. Taiwan, you have to quarantine 14 days. China has said you can't come in at all. So these are all very serious issues, because obviously physical movement of people creates transfers of money. And so if you aren't able to have physical movements of people, is right now the hot market in the San Gabriel Valley, is it really just because of the interest rate? Because the people that are purchasing, at least from my standpoint, that I'm involved in, residential and commercial, they're physically here. They are physically here in the United States. I have not met many acquisitions where the person is out of the country, sight unseen purchase. That it did occur before, but I rarely see that now. So is this a bubble based upon a low interest rate, or is this legitimate purchase and sales globally of all acquisitions based upon foreign money? I believe that really most of the acquisitions that are occurring are in-state residents that are here relying on the low interest rate. So that's a very serious issue too. Proposition 15 was lost. So what does that mean? That means that commercial taxes remain as is in the state of California. So a lot of you remember Proposition 13. Proposition 13 was very important. It capped everything really at 1% to 1.1%. Essentially how Proposition 13 works is this. If you, and forget about the 1031 exchange, please. In terms of if you acquire a property, whether it's residential or commercial, you pay 1% of taxes of the value of the property, And it's usually very close to the purchase and sale. And every year, they can be able to increase your taxes no more than 2%, no more than 2%. And so you're hoping that the value of the property is going to double, let's say within 5 years period of time, but it's only incrementally in terms of taxes 2%. So what would have Proposition 15 done? Proposition 15 would have allowed for commercial property to be taxed at fair market value, and it was going to occur over a period of time. That was shot down. Now, why is that important? Is I believe that this is still going to come up over the next few years, and that is how are we going to increase our property taxes? So here's an example of property taxes for the city of Arcadia. As you can be able to see, after Prop 13 was passed, 57%, there was a reduction of 57% of money coming into the city. Now, most people think about Proposition 13 as money into the city, but if you look at the pie graph, a majority of the money goes to the school district and the county. Special districts aren't necessarily related to Arcadia. The city actually gets a tiny bit. So a lot of cities have said, we need more money. This is very difficult. COVID is crushing us. Oh, I did not put in the slide. So let's just say on a $2 million property in the city of Arcadia, based upon Proposition 13, currently $2 million, the property taxes on it, $1,920 a year. That's how much the city of Arcadia gets. So that's just not us. That's all cities. All cities get very, very little from property taxes. And so the hope was, if Proposition 15 passed, it would allow for cities to be able to get more money. Because city income, if you can consider it income, really comes from two places. One are property taxes, and the second one relates to sales tax. Those are really 50% or more of the city's revenue. It's very hard to generate revenue. And in fact, cities, when I use the word revenue, my city manager always reminds me, no, we can't look at it as revenue, right? Everything that you do for residents has to be based upon the reasonable amount of work that you actually put in. So I'll give you an example. when I first got elected to city council, I said to myself, you know what? We need to have an empty home tax. Other places have empty home taxes. We really need to have it, and we need to charge a lot of money for it. And he said, no, we can't be able to do that. We actually have to calculate the amount of time that is spent on actually monitoring an empty home. And so all these years, this empty home tax, you know, that maybe people have brought up, maybe people hadn't brought up, is you know, something that a city can't be able to do because they have to base it upon the amount of work that they actually do. They can't generate revenue from it. So it's actually kind of something that I had learned, obviously getting on city council, but I am very proud to say that we do have an empty home, a monitoring fee that we were able to push through. I really thank all of the city council that really supported our position that empty homes aren't good for the city. That's been passed as well. And if you're interested in monitoring how much it costs, et cetera, because it's mandatory to register, you can be able to contact the city of Arcadia. So the other one is targeting people over 55. So there was a proposition that was passed. Basically, the proposition did two things. So in the state of California, before the proposition was passed, if you are over 55 and you want to move your property from, you want to essentially move residences, your county basically said, we can freeze your property tax to a different property. If it's not too much more, we'll freeze your property tax. But it depended on whether the county allowed you to. If you went to a different county and the county didn't allow you to, you couldn't do it. There was frequent movement between Los Angeles and San Diego because of the fact San Diego allowed you to do it, and then there was an agreement between both counties. So what this proposition did, it did several things. The proposition that was passed basically said, if you're over 55 and you want to move your property tax from one property to another because you're moving, you can now do it in the entire state of California 3 times. Now, there was a downside for that as well. Before this proposition passed, if you passed on your property, let's just say that my mother wanted to pass on her property to me, my property tax would be the same as my mother's property tax. So I'm going to say that again. If my mother quitclaimed to me a property that she owned before this proposition was passed, I did not have to pay a higher property tax. I paid my mother's property tax. Now that is gone. That is now gone. So this proposition was very intelligent. It basically said, hey, people over 55, they need to help people. People that are handicapped, they need help. But they didn't talk about the second portion of this proposition that eliminated the property transfers. So property transfers within the immediate family, you now have to pay a higher property tax. It is no different than selling it to your family member. So the free transfer of property between family is now eliminated. 3 minutes. Sorry, guys. Again, the Prop 19 conclusion, again, just very, very quickly, just summarized it. If you're 55 disabled, you're displaced by wildfire. You know, really, the real estate industry, they just put in disabled, displaced by wildfires because it was a really good selling point, which ended up passing Proposition 19. But again, it's really for people over 55. You need to target people over 55, in my opinion, now in 2021. You need to allow them to know that there's the law. You need to allow them to know that, look, you were in this property in Arcadia for 30 years, and now you can be able to sell the property and be able to move your property tax now over to like San Francisco, over to San Diego, et cetera. So it's a really good deal for everybody. Oh, well, I must have moved the slide. This is for Prop 13. I'll move it back when I give it back to everybody. But again, this is an example, $2 million, property taxes are $20,000. Arcadia, our respective city only gets $1,920. So really not that much. I believe Proposition 21, as it relates to local control of the landlord-tenant relationship, I think, is going to come back again. So I do want to let you know that although Proposition 21 stopped, I believe that there's every year going to be a big push in terms of getting it back on calendar and getting people to vote. Every 2 years is when we vote on propositions. So that is, and let me just confirm, that is it. So before I complete my lecture, and we just stop my sharing really quick. So every time I lecture, I have a few moments in which I share kind of my own personal beliefs and thoughts. And, I do want to say this, that COVID-19 has been just terrible. And, the November election was also very contentious. But I do want to say that, respectfully, whether it's President Trump or President Biden, is that when you're pumping gas, the person next to you that helps you pump gas, it's not going to be the president. If my mom, she's elderly and she fell down, that's not going to be the president that's going to come. The person that comes up to you and says, hey, do you have enough masks? That's not the president. They're your neighbors. And I want to say that the city of Arcadia is beautiful in the sense that we really want to be neighborly to each other. In the month of September and October, the state of California had something that no other city has ever done. For almost 60 days, the residents got together and we fed our first responders on a daily basis. Every single day. There was not one day that was missed. The reason why I share that is because I really want you to let go of the politics that have occurred and to realize that being neighborly, that's the only way that's going to save us. In 2021, I don't believe it's the president. I believe it's the neighbor next to you and the neighbor inside of you that is really going to make 2021 better. And so I just want to say thank you so much for giving me an opportunity to come to share my thoughts with you and to just have an opportunity to be able to serve you. If there's anything that the city of Arcadia can be able to do for you, as well as city council, please just let us know. Thank you very much. God bless you and have a great holiday season. Thank you.
Thanks, Paul. That was awesome.
Oh, thanks. Is anybody still on, or is I think my time lapsed, so I don't know if anybody else is still on. Okay. So are we doing Q&A, or do you? Because our time is up, I just want to be respectful of everybody's time. So I guess we're done.
Paul, this is Stephanie at the association. I've been monitoring the chat box to see if there's any questions that come in. And it seems like we don't have any questions at this time, but if anyone has any additional questions, feel free to unmute yourself or type them in the chat box, and we'll have Paul try to get to them. And if not, then we thank you so much for joining us, and thank you.
Yeah, thank you. Thank you so much. Appreciate it. Happy holidays.
Thank you, Paul.
Thanks. All right, oh yeah, copy of the slides. Yes, absolutely. I'm gonna move a couple of the slides. I did see a typo. If I can catch all of them, I have a couple of big deadlines today, but I'll definitely get it out by the end of today. If I can't fix the slides, I'm sure you guys can understand. All usable slides, very usable, not password protected. Use it, lecture on it. Good law.
And just as a reminder, we will also have a recording of this presentation posted onto our website under the on-demand content, hopefully by the end of today, if not first thing tomorrow morning.
All right. Well, thank you so much. I appreciate it. Take care. Bye.
Thanks, Paul.
Bye. Thank you.